Joseph, I'm very worried.
The sky is falling.
The sky is falling.
It was something like that actually got us to team up, right? Mm-hmm. Way back when Bill C-51 came in, and I think I was saying, it's catastrophic.
Yes, exactly.
It's catastrophic.
Well, and it was actually in terms of the changes, which, we've managed to work with and make the best of. And similar things just happened. So a new decision came out from Supreme Court, just like about a week ago, I guess, called R.V. Kruk, SCC 2024 SCC 7.
A light read.
And so I know it's extremely lengthy.
March 8th.
In part because there's two decisions. There's a majority decision written by Justice Sheila Martin, and then there's a concurring, so he agrees with the outcome, decision written by Justice Rowe. And it's mostly the majority decision, the wording of the majority decision that's got people up in arms. I found that Justice Rowe's decision was a little bit more easy to digest and a little bit, because it had less sort of social justice type language in it. So, and there's another aspect of the decision that was made a big deal about in terms of being the first time in Canada that a judge has used the word person with a vagina instead of saying woman. So it was that kind of language that I think really kind of got people up in arms and worried about what it was going to mean. When you look at it closely, though, as we've done, there's some good stuff.
Well, there
in
was reporting on it right away, and some criminal lawyers were quoted as saying it'll lead to wrongful convictions and other things. Mm-hmm. I wasn't quoted, but there were some other criminal lawyers quoted.
Well, one of the things that, one of the points it made is that it does seriously limit grounds of appeal on sexual assault cases. We were making advances in terms of myths and stereotypes about accused people and men in specific that were being recognized as errors of law, and this seems to have set that back a little bit.
Yeah, so let's sort of, as I always say, let's slow it down and let's break it down. So we all know that over the last 15 years, there's been a correct movement in criminal law. Hi, honey. How are you?
Hi. Like, share, and subscribe to the podcast.
Thank you, Rachel Neuberger. I love you.
I appreciate your affection. Okay, bye.
Bye. So case law has properly been moving in the direction to remove discriminatory beliefs used against women in sexual assault cases. Mm-hmm. Give us some examples. These are myths and stereotypes that have been ruled out, and if relied upon by a judge, it's an automatic error of law, and if it's an acquittal, it gets overturned.
So the core ones that are not as new is called the twin myths, which is to say that it's wrong to say that a complainant, usually women, are if they have some prior sexual history, by the sexual nature of that activity, they're less worthy of belief and more likely to have consented. So those are the twin myths. But since that, there's been other recognized myths. One really common one is the doctrine of recent complaint, which is to say that if somebody doesn't make a complaint in a timely manner, that they're less likely to be telling the truth because a real victim, anything that comes along with a real victim would do this thing, is considered to be generally a myth or stereotype. So a real victim wouldn't continue a relationship. That's a myth.
Correct.
So there's
real victims of sexual assault should have visible injuries.
Yeah, and then of course there's things too.
A complainant who said no did not necessarily mean no, and may have said yes.
Yeah, and somebody wearing that type of outfit was obviously likely to consent because the nature of the outfit they were wearing being too sexy or something.
If a complainant remained passive or failed to resist the accused advances, either physically or verbally, by saying no, she must have consented. Right. These are all examples of really myths and stereotypes about how a real victim would behave. And they're incorrect, and they're based on discriminatory beliefs, and they have been there's been strong work done to root them out of sexual assault cases.
And one of the things about those particular myths is that, like they said, it often was hidden under the guise of common sense. So a judge would say, common sense tells me that a real victim would, whatever that myth is that's being employed. And so common sense developed a bad rep in the courts. To the point where if you mention to a judge, well, common sense tells you something, as soon as the words common sense came out, the judge would almost visibly cringe because common sense was basically vilified for a while.
That's right. So, in fact, it was ruled out. So, much was thought about that common sense is based upon stereotypical discriminatory beliefs about women, and therefore it's not appropriate to rely on common sense when trying to determine credibility and reliability in a sexual assault case. So that's sort of the backdrop. And then there's a line of appeal cases that's come up over the last several years about ungrounded assumptions about accused persons, which in particular were male accused persons. And I do pause for a moment. Something that I think was good about the way Justice Martin had wrote this is that she's trying to take the gender out of sexual assault, which I think is actually a very good thing, because it recognizes that men can be sexually assaulted, boys can be sexually assaulted, as we know, same-sex partners, all sorts of things. So I don't disagree with that at all, and I think that was actually quite useful to have in this decision. That said, typically we have a male accused, and there have been a number of convictions based upon stereotypes about men, and I'm just using the term stereotypes. So, for example, a young, strong male in bed with a naked female would definitely want to have sex, and the thought of him not having sex with her or trying to have sex with her would be at odds with common sense.
Yeah, inconceivable. There's a few words that that we've come across in decisions that have been overturned because of stereotypes or assumptions about men or an accused person.
Can you give another couple of examples so we can frame this for everybody?
Well, if they use words like it's inconceivable or that outrageous or really dramatic words that are used in discounting the testimony of the accused person, saying why they didn't believe them. It's like, well, why is it unbelievable? And in a number of these cases, it was because they didn't believe that men would act in a certain way, or sometimes they didn't believe that a young woman would agree to a certain thing.
Right.
And that was a stereotype that actually was about women, but it worked against the accused person, and it wasn't grounded. For an example, there was a case where the judge had decided that a young woman would not have gone outside in the weather conditions and laid down on ground that was cold or wet or something like that in order to have sex. But that's, there was no evidence from this particular young woman saying that she would never have done that. It was just an assumption by the judge that no young woman would do that.
Right.
And so then that went into the territory of reversible error.
Okay, so as a result of a number of these ungrounded assumptions, as we call them, or the stereotypical beliefs about the way a male would act, stereotypes about male sexual aggression, there were a line of Court of Appeal cases that were rooting out these ungrounded assumptions, or stereotypes as we call them, and finding that when a judge relied upon one of these erroneous assumptions, that amounted to an error of law, therefore overturned the conviction back for a new trial. So, and there are a number of those cases that were incredibly important. Chepik,
Roth,
JC, there's another one.
Codwat
is a very important one.
Yeah, Codwat, that was an issue where they said no young woman would have sex with a man that was that much older than her.
Right.
So it was an age issue where they just said, I don't believe that any young woman would have consented to that.
Right, so these are four very important cases, okay? So the first thing that Justice Martin tries to do is to say it is wrong, it's inappropriate to take these ungrounded assumptions about accused persons and equate them at the same level as the stereotypes and myths against female accused persons, because those are based upon discriminatory beliefs. And it
more pernicious, I think, is a good way of describing the comparison. That the stereotypes about complainants are more pernicious than the common sense assumptions that have been used on convictions to arrive at a conviction.
So, what the court said is it would be equally wrong. The Supreme Court said it would be equally wrong to draw inferences from stereotypes about the way accused persons are expected to act. The proposed rule by the appellate courts was that if a judge made one of these erroneous or ungrounded assumptions about an accused, an error of law would automatically result, as I've said before, to ordering a new trial. Her Honor goes on to state, embracing the proposed rule, other courts have agreed that this established error of law pertaining to myths and stereotypes about sexual assault complainants must also extend to other types of stereotypes or factual assumptions that can work to undermine an accused's testimony. Collectively, these cases advance the notion that although myths and stereotypes have traditionally operated to prejudice complainants, these same myths and stereotypes can simultaneously prejudice the accused. The parallel treatment proffered in this line of cases is at the forefront of the cases on that appeal. The proposed rule against ungrounded common sense assumptions thus represents a radical departure from how appellate courts have typically approached credibility and reliability assessments, especially in the context of sexual assault. Crucially, the rule transformed all factual findings that could be said to constitute assumptions, which in the ordinary course were previously subject to review for palpable and overriding error, into errors of law reviewable on a standard of correctness. Everybody's going to roll their eyes and gloss over on this one.
There's a lot in there to unpack.
But I got it. We got to go through this for people to understand.
So the palpable and overriding error is a big theme here, and that's that it has to be something that was that the overriding thing is that it played an important role in the decision making in terms of the conviction or acquittal, and that it was obviously wrong, being palpable.
So let's help everybody with this. So, because frankly, we needed some help when we were reading it. So the line of cases that we've spoken about created a ground of appeal that would be an error of law, and was assessed on the basis of correctness, meaning that if the court found that there was this erroneous or ungrounded assumption about a male accused, then that amounted to an error of law, which on the standard of correctness means the conviction is tossed out, you don't have to do any more assessment of it, order a new trial. Now, the Supreme Court has said, no, that's wrong, we can't do that. That puts it at the same level as how we deal with myths and stereotypes about victims of sexual violence. Right. So we're going to pause on that. We're going to come back to that later, and I'm sure you're going to have a lot to say about that, because I think we do have to talk about that. In other words, the court wanted to avoid symmetry between these ungrounded assumptions about accused and complainants of sexual assault. Okay, but let me just go into this. I'm sorry. Again, it's like last time I was apologizing about the academic nature of this, but I think it's important for people to understand, especially to have, sort of an informative approach to these podcasts sometimes. So just bear with me, okay? Here's the legal argument. What the does the standard of a palpable and overriding error mean? Okay. So an appeal court, or as we call it, the reviewing court, must first determine whether the erroneous reliance on the assumption, so all men would sexually assault a naked female. Mm-hmm. Let's use that as a hypothetical. Is the assumption plainly seen, plainly identified, or obvious? In other words, does it really stand out to you as being, wrong? So palpable errors will include assumptions that are obviously untrue on its face or highly inappropriate in light of other accepted evidence or findings in the case. Go ahead.
Well, I think it's important to note at the beginning, too, that they did recognize that just because something could be a myth or a stereotype does not always make it such. That sometimes in a case, let's say somebody lied about a sexual assault because they were trying to avoid getting caught cheating on their partner, that could fall into a myth or stereotype. We've had that happen before, where any motive that we've put forward has been called a myth or stereotype, but sometimes it's grounded in the evidence that comes out at trial.
Okay, so let's take from that then. So if it's not grounded in the evidence, so if there's no evidence called that all men would sexually assault a naked female in their bed. Okay? Then you might say it's plainly seen. It's odd wording, plainly identified. I like the term obvious. It's an obvious fact that's not true or not supported by other evidence. That's palpable. Okay? Mm-hmm. Now, if the appeal court finds there is a palpable error, the court needs to go on to another step. Let me contrast. If in the other line of cases you had found that it was an erroneous assumption, not based on any fact in the case, it would be assessed on the level of correctness. Done. Analysis over. However, in order to get to a new trial and overturn a conviction, the court still has to go on and assess if the reliance on the assumption was overriding. In that, it's shown to have affected the result or goes to the very core of the outcome of the case. If it cannot be shown that the error was palpable, I'm reading from our actual blog, okay? If it cannot be shown that the error was palpable in overriding, a trial judge's assessment of credibility or reliability, important, will be entitled to deference, and there will be no basis for overturning the conviction. I'm going to stop. This blog is on our website at nrlawyers.com under our news and blogs, and we type it all out there if you want to go and look at it. I'm not trying to promote our website, but it's important if you want to do it because it's like marbles in my mouth with this.
It's called the article is called "The Use of Common Sense Assumptions at Trial." Thank
you. So again,
we can give an example from this particular case. There's actually two cases heard in tangent with each other.
So I'll go to you right now. Let me just do this again. So it has to be a reliance on the assumption that is shown to have affected the result or goes to the very core of the outcome of the case. It's got to be really a central feature that the judge relied upon for a conviction. Otherwise, the appeal court can say, it wasn't that central, wouldn't have really affected the outcome if they weren't relying on it, and we defer to the judge's own assessment of credibility and reliability because they were the ones at the trial. That's a big hurdle. It does reach a higher threshold to try and overturn a conviction based upon this test.
So, for example, in this case, the case is called Kruk, but it was heard in tangent with another one called Sang. And in that case, they found that the judge had committed an error in thinking that the accused person driving away from the complainant's home at a very fast speed, dropping her off and then just zooming away, was some sort of sign of a guilty mind, and that an innocent person wouldn't have driven away in that manner. So they found that to be an error, but there were so many other reasons why the judge rejected their testimony and believed the complainant that it really didn't have it wasn't a turning point for the conviction.
So let's just flesh that out a little bit more, because that's a very good point. So in that case, the judge had other evidence to rely on to support his assessment of credibility and reliability and come to a verdict of guilty. So there was other evidence that supported and was circumstantially supportive of the credibility of the complainant.
Right. And so that was kind of just like a sort of a tacked on afterthought, to the decision. That if you were to remove that, then the conviction was still pretty solid in terms of the other reasons given. Let's
give a hypothetical. The judge in giving the ruling says, or the decision, well, I find the accused evidence hard to believe that, he was so careful about obtaining consent all the way through. It just defies, how you would think a man would behave in these circumstances. But leaving that aside, why I'm convicting is because of the following. So the judge gives a throwaway to say, I don't really believe when he says that at every step of the way he was trying to secure consent. That seems a bit contrived. But leaving that aside, here's 5 reasons why I am convicted. It has nothing to do with my throwaway comment.
And that's an interesting example because that actually was one of the successful grounds of appeal in JC, right, in which the person was asking for consent at every step, and then the judge said that they didn't find that anybody would actually be that careful about consent, which of course is how we're training people to try and obtain consent now. So they said that it was too perfect or something like that. And
right.
And so,
it was
so
contrived.
That was,
too perfect and contrived.
But that was a successful ground of appeal in that particular case.
So let me just sort of close the loop on this for a moment. And and I just want to be careful about this because it's the end. It's the end of. I don't want to say an era, but it's the end of I think what was a very compelling, helpful, balancing line of cases for appeals and for assessment of accused evidence that now is at an end. And I do think that in order to overturn a conviction when there is reliance upon an ungrounded assumption, that it is a higher threshold for an accused and will make it more difficult to overturn what could be a wrongful conviction.
And, to be fair to the people who are saying that this is, a terrible decision in the minds of defense lawyers, and there were a number of comments in there saying that certain rules only apply to acquittals when an acquittal is being challenged, and it doesn't apply to convictions. And it's that type of language, I think, that had people up in arms, because it basically made it sound like an accused is a second-class citizen in a trial.
And it's not. And I have to say, Justice Martin does a good job to lay out there are a lot of measures and principles and rules in place about accused, including the presumption of innocence, proof beyond a reasonable doubt, WD, even though she does mention JJRD, which really is just a pain in the ass. Yeah. But there are a lot of built-in protections for accused persons. But she does say the proponents of the rule against ungrounded common sense assumptions argue, I've left the word common sense out, and we're going to come back to that, but that's what they're saying it is. The proponents of the rule against ungrounded common sense assumptions argue that if reliance on myths and stereotypes about complainants is an error of law, then all unfounded and speculative assumptions about all witnesses, including the accused, should be treated in the same manner. With respect, Justice Martin wrote, this impulse towards symmetry and formally identical treatment is unwarranted. It reflects a misunderstanding of the distinct body of law associated with myths and stereotypes in sexual assault cases, which developed in a particular historical context to protect complainants alone. Done. This is over now.
But, I was thinking about a case that we've talked about before, and one of the things that really resonated with the judge, and this is kind of what she's talking about, and why we've said before, judges need to use common sense sometimes. Where we said, when somebody's memory is like a blackboard that can be erased and rewritten at will, then we have to, be very cautious about accepting that evidence. And in a way, that statement, requires the use of common sense to say, well, what is memory, and can I rely on certain things? So this is one of the points that they tried to make in this decision, was that all judges require the use of common sense, just as we tell juries to use their common sense when they're weighing the evidence. So common sense in itself was becoming a dirty word, and now they've kind of rescued common sense and brought it back again. But they were concerned that decisions were being overturned just because there was use of some sort of assumption or common sense, which actually was a reasonable, and that's a word that they use a lot too, reasonable conclusion to make. And so then they clarify as well to say what you want to look at when you're looking at assumptions is, was it unreasonable? And if it was unreasonable, then yes, it could be a reversible error of law.
So let's make lemonade of lemons for a moment then, as you're saying now.
Yeah.
So as we may have in a title of our newsletter that will be coming out soon, The Return of Common Sense, where we may have captions of all the Supreme Court judges with lightsabers, but not red ones.
Think you do.
Good one. That's Yoda. Few things. So the majority does say clearly that reliance on illogical, untrue, or otherwise improper assumptions in assessing the evidence of an accused is wrong and remains reversible on appeal if it amounts to palpable and overriding error. It's just that such ordinary factual assumptions cannot be recognized wholesale as standalone errors of law. Okay, so let's drill down on that for a second. Maybe, it isn't that high of a threshold, or we shouldn't be that freaked out about it. Mm-hmm. Maybe this can be read in the context of the court wanting to be careful about identifying discriminatory beliefs as the basis for why myths and stereotypes about complainants does amount to an error of law, to root out a historical bias and discrimination, and the actual standard for review of illogical, untrue, or improper assumptions on a palpable and overriding error standard really isn't that bad. If it really is a dumb assumption, not grounded in evidence, it might result in a reversible error.
Maybe a biased assumption.
Biased assumption, you're still going to get the same result. Maybe because of Justice Rowe's flowchart.
I know. I love that he put a flowchart in there.
Excellent. That's so good, because we say negative things about the Supreme Court, but I have to say, putting it in the chart is an excellent idea, because so many times you get like a very short decision like this, and for the other courts, the trial courts, to operate it with, and lawyers and crowns, you have to really piece it together. Having a chart is amazing.
Yeah, and it's basically a, if this, then move to this one. If the answer is yes, if the answer is no, go down here to the next stage, right?
And the way it's categorized, it's extremely helpful.
It is.
And so when you have that, maybe this will provide good guidance. Maybe it will help, frankly, and I think we can use it at trial to say, let's look at these factors this way, Your Honor, when you're doing submissions. And we do this anyways with written submissions. We're very, 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 very strategic in drafting written submissions and grounding the evidence.
I actually think this decision is good for trials, because we can now, go back to saying it's okay to have common sense about this. It's a little scarier for appeals, but it could help people at trial, I think.
So we're going to go on to another case that just came out after this, but just a couple more lemonade issues. So we have sort of the return of common sense. The court clearly says common sense is used in assessments of credibility and reliability, and about grounded, ways in how we understand human behavior and human interaction. Here's another good comment on paragraph 65. Just because the evidence happens to align with a myth or a stereotype does not necessarily mean that any inferences that can be drawn from the evidence will be prejudicial. This is in line with JC and other decisions that have said, just because it can lead to a myth-based reasoning, that doesn't mean it's inadmissible.
Right. So they've kept that principle alive. And I think that was one of the most important things about JC.
So now I take a little bit concern with this, but Her Honor says, while it is a myth that women regularly fabricate allegations of sexual assault, it is not an error to consider whether the circumstances of a particular case support the existence of a motive to fabricate. Indeed, where the defense adduces evidence on this point, a trial judge is obliged to consider and to give it full effect to the presumption of innocence, and failure to do so constitutes reversible error. This is a important paragraph.
We've had a few cases like that, actually, where the decision of the judge actually just didn't grapple with the motive that was presented.
Yeah, so
they didn't reject it, they just didn't even deal with it.
I think paragraph 65, and I think Justice Martin has done a lot of, I'm going to quote two paragraphs actually to back up, but I think there are two very important paragraphs, 64 and 65, which I think has gone a long way to helping trial courts, more so than before in other decisions. So let me just, I'm sorry, there's just juicy here and I just want to talk about it. So paragraph 64.
Back one paragraph to
I know, because I want to put it into context.
Just to be clear that this is the preceding paragraph to what we just read.
Paragraph 64, I'm sorry. It must also be emphasized that the concept of myths and stereotypes concerning sexual assault complainants is not unbounded. It's blah, blah, blah. Some scholars have suggested that the laws of myths and stereotypes is presently being overused in contexts where it's inappropriate or applied without rigor. And that's Lisa Fairmont?
Yeah, who we've cited quite often as well.
And her article is excellent. So that was the lead-in to what Her Honor said, essentially, in paragraph 65, which I think is extremely important. Mm-hmm. The Supreme Court of Canada has said clearly, that just because evidence happens to align with a myth or a stereotype does not mean necessarily that the inferences that can be drawn from them will be prejudicial.
So a good, clean example of that would be this doctrine of recent complaint. Sometimes we'll point out the timing of a complaint, not because we're saying that, it took them so long to report, but because that timing aligned with some other event that
could then be motive to fabricate.
Right.
Let's try and give an example, okay? A person a year and a half after the event went to the police and made a number of allegations, including the sexual assault. It's not, and they were in a relationship for that period of time. The sex assault in this hypothetical scenario occurred at the start of the relationship, okay? 2 myths. 1, the late reporting of it is irrelevant, and the fact that the person remained in a relationship is irrelevant. Even though many of you out there will go, "Oh, come on, it's relevant." But the timing of when reporting it to police is relevant not because it was a year and a half later. It's because at that time, the accused ended the relationship permanently with the complainant and demanded the return of funds in relation to something they had planned together. Mm-hmm. Stop. So it is not about the lateness of reporting. It's about when and why.
Right.
That's
a great example of grounding it in the evidence.
Well, thank you. So, this stuff isn't easy. Like, you have to really think about each piece of evidence and line it up to get this right, to avoid the myth-based reasoning and to make sure it's relevant, to try and get across to the court why they have to carefully consider this. And thanks to Her Honor saying this from the Supreme Court, if I'm wrong, this is the first clear statement since, the change in legislation and everything we've heard up till now. C. Boyer did say this, but I think since all of the changes in legislation and the shifting with respect to common sense inferences and all that stuff, this is the first refreshed statement we have from the Supreme Court of Canada that says just because it could lead to impermissible reasoning doesn't mean it's prejudicial, and in fact it may be relevant. Second, it's very clear that although we never say that people, women or others, regularly fabricate. We say there is fabrication. It's not insignificant. It's statistically significant. Leaving that aside, the judge says very clearly, Her Honor Justice Martin clearly says, it would be an error, a reversible error, for a judge not to consider and give it full effect with the presumption of innocence to consider fabrication, a motive to fabricate. That's very important.
It is.
So I think paragraphs 64, 65 are very important for trial courts and for defense lawyers conducting their defenses and for Crown attorneys how they're running the cases.
Yeah, and looking at our takeaway about this return of common sense, as you mentioned, there's a new case that came out in the provincial courts of Alberta, which is RVLA 2024 ABCJ 70, in which there's a short little section citing the Kruk decision, and the title of that section is "The Role of Common Sense," in which the judge says, "The Supreme Court of Canada very recently outlined the connection of common sense to the assessment of testimony by trial courts," with the Kruk citation, and they confirmed, "Common sense assumptions necessarily underlie all credibility and reliability assessments. Credibility can only be assessed against a general understanding of the way things can and do happen. It is by applying common sense and generalizing based on their accumulated knowledge about human behavior that trial judges assess whether a narrative is plausible or inherently improbable." And there's more to that quote, but that comes directly from Kruk. So it's nice to see that that's how the lower courts are taking that decision and using it as well to reinforce their ability to use common sense. I find that encouraging.
Yeah, I think it's more than encouraging. I this is a great find. you pulled this case out. We're going to add this to the newsletter. And, His Majesty the King versus L.A., very recent decision of March 14th. It's extremely important because it really is the return of common sense. Yes. And it clearly states, relying upon the Supreme Court of Canada, common sense underpins well-established principles guiding credibility assessment, including the now universal idea, blah, blah, blah. That's great.
What they're watching for is something that's masquerading as common sense, but it's really some sort of a, obviously wrong assumption about what men would do, what women would do, or what people in general would do, and where they no longer are looking at the evidence about those individuals, and they're making assumptions about everybody and how they think normal people would act.
Right, and this brings this down to, I think, a proper analysis of how you deal with credibility and reliability. And we do say this, we look at a set of facts and try and determine, is this really highly improbable and why? And let's ground it in the evidence. But we also do, to a certain extent, let's take common sense. Remember paragraph 111 of Justice Quigley's decision, which is an excellent, should be much more quoted paragraph. Common sense does play a factor. And now we've had the Supreme Court of Canada saying that. And immediately, less than a week later, a trial court quoting it. So I think the lemonade here is actually quite tasty.
Yeah, I agree.
It's sweetened lemonade. I think it's okay. Is that it? Am I supposed to stop talking now? Okay.
The sky's not falling.
The sky's not falling. No, yeah. Glad we got through that one. I feel like I'm doing one of those monologues in SNL. It's highly inappropriate,
And so if you like this podcast and you want to see more, don't forget to like, comment, subscribe, share, and generally just enjoy.
Support us, enjoy it, and keep sending in those questions. Thank you.
And make sure you spread it around so other people can learn what you've just learned today.
Good night, guys. Good night.